So I have with me Brian Leiter, who is a professor of law at the University of Chicago. He's a legal theorist, and recently he published a book, about a couple of years ago, I think.
2013.
2013. He published a book which created a significant resonance, and the main thesis of the book was to challenge the axiomatic notion in American constitutional legal theory and American constitutional thinking that freedom of religion deserves special protection. So maybe we could get the conversation going by you explaining to us the major thesis of the book, why you think freedom of religion does not deserve, or maybe it's even inimical to a good society that freedom of religion gets special protection.
So my book has the provocative title, Why Tolerate Religion? But the answer to the title question is that the reasons for tolerating religion are not specific or peculiar to religion. So I think there's a strong case for liberty of religious conscience, but it's not peculiar to it being religious conscience. And that's the central thesis I'm defending, is that in Western democracies we have a fundamental inequality now between claims of religious conscience, which have standing to go to court and challenge the application of a neutral general law to them, and claims of non-religious conscience, which typically don't have such standing, with the one exception of military conscription. In one way or another, even the United States has found a way to permit non-religious conscientious objection to military conscription. We know the historical reasons why freedom of religion has been so important. The bloody experience of the early modern Europe taught us all a lesson about the importance of live and let live. The question I'm interested in is whether in the 21st century, in which there are conscientious commitments that people have whose sources do not derive from religion, whether this kind of inequality in status between religious and non-religious conscience can be justified. In my book, I explore different arguments in sort of the secular traditions of moral theory for toleration, for liberty of conscience. I draw mainly on arguments associated with the American political philosopher John Rawls and the great English utilitarian philosopher John Stuart Mill. And I conclude these are compelling arguments for liberty of conscience, but then I go on to argue in the book that these kinds of moral arguments do not single out religious conscience as more important than other kinds of conscience.
So it's sometimes said, when thinking about this argument, that it has force to it, but religion is not only privileged, but it's also in some way discriminated against. In European constitutional theory, for example, the European Court of Human Rights always says there's freedom of religion, but there's also freedom from religion. And they never say, for example, there's freedom to be a socialist, but there's also freedom from socialism. If you get a majority in parliament, you can have a socialist government, but you can't have a Christian government because there's freedom from religion. So isn't there some kind of, the two things sort of balance themselves out?
Well, I don't know if it adds up to a balance, but what you say about the European context is certainly quite interesting and very foreign, as you know, to the United States, where no one would make the argument you have a right to freedom from religion. Of course, what we do have in the European experience are established religions in many, many countries. Though one of the things I argue in the book is that the establishment of religion is compatible under certain circumstances with religious toleration. I think the Church of England is a perfectly good example, an established church, but I think by any measure England constitutes a tolerant country that respects the rights of religious minorities as well as the religious majority.
Because that seems to be exactly the European settlement.
Yeah.
That you will allow an established church like the Church of England because it has to live also with the constitutional principle of freedom from religion. So as long as it's at the identitarian, at the symbolic level, but nobody can be subject to any form of religion coercion.
Yes. Right, and I think that's actually central to any scheme of religious toleration, that there isn't coercion.
But would you say that there's any merit in an argument that since we treat religion specifically also in a negative sense, unlike other ideologies, and say, no, there has to be freedom from religion, that in some ways that might explain or even justify that we privilege also on the side of the extra protection that it gets?
I think it depends on what exactly freedom from religion means in practice. If what it means is freedom from religious coercion, right, then it's not very different than the regime we even have in the United States, right? The special thing about what free exercise of religion or liberty of religious conscience means is that laws that apply to everyone else may not apply to someone who has a religious objection to the law. Now, the really curious thing about the European context, from my point of view, and I discuss a number of important European cases in the book, but the curious thing is many of the European constitutions, the European Convention on Human Rights, all mention liberty of conscience as well as religious liberty. Of course, the American Constitution talks only of the free exercise of religion, so there's no textual basis for a constitutional claim of liberty of conscience.
And that's exactly the fact that we find both protection of liberty of conscience and freedom of religion is why, on an empirical level, I've puzzled over, so why is it so? And I say maybe it's because of this balancing thing. Tell me, because we don't have a lot of time, the patient span of YouTube watchers is limited. How does your argument play out in international law, where I practically cannot think of a single instrument protecting fundamental human rights at the international level which does not single out freedom of religion rather than only freedom of conscience? Because you would say the really appropriate thing is to say freedom of conscience, and religion is just subsumed by that.
Right. So what I would say at the international level is that we ought to follow the lead of the European Convention on Human Rights, the Constitution of Canada, all of which treat liberty of conscience as a fundamental constitutional right. The puzzle, it seems to me, about many of the European countries and in Canada is that we don't see successful claims by non-religious conscientious objectors, except in one context, military conscription.
But just to press you on this, so you would be comfortable, you say, as long as they specifically mention freedom of conscience, you're not so troubled that they single out, in addition, freedom of religion? I
think we understand the historical reason why it's there, but strictly speaking, it's redundant in my view, right? That is, if it were really about liberty of conscience, it would, of course, encompass the liberty of religious conscience, and we wouldn't need to mention it at all. But history looms large in law as in life.
But as you know, the fact that it is mentioned specifically in addition to freedom of conscience means that it is also treated differently and maybe in a privileged way.
Right.
So to our viewers of EJIL Life, this again is Brian Leiter, one of the most prominent American legal theorists, professor of law at the University of Chicago. And if you haven't read the book, here is a trailer and an incentive to go and read it. It will really enrich your thinking about the whole problem of freedom of religion and freedom from religion, also in the international context. Brian, thank you very much.
Thank you, Professor Weiler.
Great.